Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in CASSIRER versus THYSSEN-BORNEMIZZA Collection Foundation, certiorari to the United States Court of Appeals for the Ninth Circuit. Argued January 18th, 2022. Decided April 21st, 2022. The Foreign Sovereign Immunities Act of 1976, FSIA, 28 U.S.C. Section 1602 et sec. Governs whether a foreign state or instrumentality is amenable to suit in an American court. The question in this case is what choice of law rule a court should use to determine the applicable substantive law in an FSIA suit, raising non-federal claims. That issue arises in a dispute concerning the ownership of an impressionist painting, Carmile Pissarro's Rue Saint-Honoré in the Afternoon Effect of Rain. Lily Cassirer inherited the painting which a family member had purchased from Pissarro's agent in 1900. After the Nazis came to power in Germany, Lily surrendered Rue Saint-Honore to them to obtain an exit visa. Lily and her grandson, Claude, eventually ended up in the United States. The family's post-war search for Rue Saint-Honore was unsuccessful. In the early 1900s, the painting was purchased by the THYSSEN-BORNEMIZZA Collection Foundation, an entity created and controlled by the Kingdom of Spain. Claude learned several years later that Rue Saint-Honore was listed in a catalog of the Foundation's museum. Claude sued the Foundation, asserting various property law claims based on the allegation that he owned Rue Saint-Honore and was entitled to its return. Because the Foundation is an instrumentality of the Kingdom of Spain, the complaint invoked the FSIA to establish the court's jurisdiction. See Section 1603B. The FSIA provides foreign states and their instrumentalities with immunity from suit unless the claim falls within a specified exception. See Sections 1605 to 1607. The courts below held that the Nazi confiscation of Rue Saint-Honore brought Claude's suit against the Foundation within the FSIA exception for expropriated property. See Section 1605A3. That meant the Cassirer's family suit could go forward. To determine what property law governed the dispute, the courts below had to apply a choice of law rule. The Cassirer plaintiffs urged the use of California's choice of law rule. The Foundation advocated a rule based in federal common law. The courts below picked the federal option. That option, they then held, commanded use of the property law of Spain, not California. Applying Spanish law, the courts determined that the Foundation was the rightful owner. This court granted certiorari to reserve a conflict among the courts of appeals as to what choice of law rule a court should apply in an FSIA case raising non-federal claims. The Supreme Court held the decision below is vacated and remanded, and Justice Kagan delivered the opinion. In an FSIA suit raising non-federal claims against a foreign state or instrumentality, a court should determine the substantive law by using the same choice of law rule applicable in a similar suit against a private party. Here, that means applying the forum state's choice of law rule, not a rule deriving from federal common law. The FSIA provides a baseline principle of foreign sovereign immunity from civil actions unless a statutory exception applies, including the expropriation exception found to apply here. See Sections 1604 to 1607. Yet, the FSIA was never intended to affect the substantive law determining the liability of a foreign state or instrumentality deemed amenable to suit. That's First National Citibank versus Banco para el Comercio Exterior de Cuba. To the contrary, Section 1606 of the statute provides As to any claim for relief with respect to which a foreign state is not entitled to immunity under the FSIA, the foreign state shall be liable in the same manner and to the same extent as a private individual under like circumstances. When a foreign state is not immune from suit, it is subject to the same rules of liability, the same substantive law, as a private party. See again First National City Bank at 622, note 11. Section 1606 dictates the selection of a choice of law rule. It must mirror the rule that would apply in a similar suit between private parties. Only the same choice of law rule can guarantee use of the same substantive law, and thus guarantee the same liability. Consider two suits seeking recovery of a painting. One suit against a foreign state-controlled museum, as here, the other against a private museum. If the choice of law rules in the two suits differed, so might the substantive law chosen. And if the substantive law differed, so might the suit's outcomes. Contrary to Section 1606, the two museums would not be liable to the same manner and to the same extent. In this case, Section 1606 requires the use of California's choice of law rule, because that is the rule a court would use in comparable private litigation. Consider the just hypothesized suit against a private museum, brought as this case was in California, and asserting non-federal claims. If the private suit were filed in state court, California's choice of law rule would govern, and if the private suit were filed in federal court, the same would be true, because a federal court sitting in diversity borrows the forum state's choice of law rule. See Claxton versus Stenner Electric. If California's choice of law rule applies in the private museum suit, it must also apply in the suit here against the foundation. That is the only way to ensure a Section 1606. That is the only way to ensure, as Section 1606 demands, that the foundation, although a Spanish instrumentality, will be liable in the same way as a private party. Even absent the clarity of Section 1606, the court would likely reach the same result. Scant justification exists for federal common lawmaking in this context. Judicial creation of a federal common law to displace state-created rules must be necessary to protect uniquely federal interests. See Texas Industries versus Radcliffe Materials. While foreign relations is an interest of that kind, here, even the federal government disclaims any necessity for a federal choice of law rule in FSIA suits, raising non-federal claims. The decision below is vacated and remanded. Justice Kagan delivered the opinion for a unanimous court. If you'd like to support me or support the podcast or support public defense in Eastern Pennsylvania, find a PayPal link in the show notes, or get a hold of me at rhodesscholar80@gmail.com. That's ROADS and the number 80. Talk at you later.